and welcome to this month's episode of The Legal Scoop, episode 29. I'm your host, Brendan Shannon. I'm an associate attorney here at LOMAD, and today I want to talk about some recent developments involving mental injury claims. Now, as many of you probably remember, the way to defend these claims is that we would produce a witness who could testify to basically the normal work environment and proving that the stress that the claimant is alleging to have been exposed to would not be out of the ordinary course of that employment. Recently, as many of you are probably also aware, there have been strange developments in the law. And when I say strange, I mean that there's been now multiple amendments to the law that have made it a little bit confusing to follow. There's also been some pretty notable decisions from the Third Department, one of which, matter of Anderson, we addressed, James and I addressed in our annual case law update for the 2024 cases. So I want to talk about that today because there's been more development in 2025 through case law as well as with the amendments. So bearing what the law used to be in mind, there was an amendment that went into effect on January 1st that broadened the scope of the law to say that where a worker files a claim for mental injury premised upon extraordinary work-related stress incurred at work, the board may not disallow the claim upon the factual finding that the stress was not greater than that which usually occurs in the normal work environment. Now, when this first came out, everyone sort of panicked, thinking that the prior defense of arguing and producing evidence to support this argument that the claimant was, exposed to normal stressors that employees similarly situated at that place of employment would expect to be exposed to would be enough to defend that mental injury claim. However, with this, it sounds as though that defense would not work. Now, I have some comments on that and why we think that's not the case, but that's what the law is as of January 1st, 2025. Basically, any worker can file a claim for a mental injury only case, and it won't be disallowed solely on a finding that, stress was not greater than that, which usually occurs in the normal work environment. However, if you read that a little bit more closely, it does mention that the claim must be premised upon extraordinary work-related stress. So our interpretation of that provision is that it's functionally the same as the prior standard, and that you still would want to produce evidence that the stress that the claimant was exposed to was not out of the ordinary. Now, that amendment is only effective until June 4th of 2025, as there were chapter amendments signed by the governor, which basically reined in a little bit, but not that much. We now have provisions providing that, emergency workers can have mental injury claims. It used to be that they would have a difficult time getting a mental injury claim established because they are normally exposed to highly stressful events. Now, similar language, if they can prove that, their mental injury arose out of extraordinary work-related stress, they can get a claim established. And again, it also provides that, any covered employee may get a claim established for, and it's very specific, PTSD, acute stress disorder, or major depressive disorder resulting from work-related stress that arose out of extraordinary work-related stress attributable to a distinct work-related event or events directly related to the employment. Now, that will be the law as of June 4th, and it's a little bit different and a little bit less broad than the amendment that went into place on January 1st, so that's something that we can be happy about. But now I just want to briefly discuss recent case law and kind of how we think we can approach mental injury claims in light of the developments in the law. And I hope everyone's following along. It is actually a little confusing because there's been a lot of developments, but I think our discussions of it here at LOMAD should sort of calm your nerves a little bit, because we think that it's sort of business as usual with mental injury claims. Now, there was a recent decision in Waddy v. Manhattan and Bronx Surface Transit Authority involving a mental injury claim. Now, this would have been the prior law before even the January 1st Amendment. But because it discusses Anderson, the third department case from last year, and uses the exact language that's in these new amendments, which is the extraordinary stress at work, we feel that it provides sort of a blueprint for how to defend these claims. Now, in this case, the claimant was an MTA bus driver, and a potential passenger became irate at the fact that the claimant denied the passenger access to the bus. He went basically crazy, was punching at the bus and tried to jump on the bus and climb in through the window. It was a mess. But the MTA managed to produce, a witness or witnesses who testified that it's very normal for bus drivers to encounter irate passengers, and it's actually not even that out of the normal or out of the ordinary for a passenger to get so mad that they might try and damage property. So basically, in this case, it discussed that in Anderson, the court clarified that the standard for a mental injury claim requires a consideration into whether the alleged stressor was unusual, unexpected, or extraordinary. The same language that's in the amended statute. So basically, while a claim can't be solely disallowed now on a finding that it's a similarly situated employee would be exposed to the same stress, they are still considering whether the stress event was extraordinary. And if similarly situated employees are exposed to the same stresses, it would be hard to argue that the stress event was extraordinary. So our recommendation would be to continue defending these mental injury claims as we always have, with getting witnesses and evidence to support that the stress that the claimant was exposed to could be expected. And the one thing we'll just note with Waddy, it's not that the witnesses testified that people always jump on the bus and try and reach into the window and assault the bus driver. They just said that passengers become irate and passengers sometimes damage the property. And that's an important distinction because it means that we can produce witnesses who don't necessarily have to testify that the exact occurrence that supposedly caused stress always happens. We just need to find witnesses, assuming it's, that it's true, who can basically prove that something like the event that supposedly caused stress could be expected to happen in the ordinary course of their employment. So that's all we've got today. It's a lot of information to digest. If you have any questions about that, we recommend reaching out to defense counsel. At LOMAD, we do have case law squibs addressing last year's developments, including the Anderson case. We will have a new one for 2025 addressing Waddy, whatever other cases come along. And I know anyone here would be happy to talk about the developments in the statute. So we'll be back next month. If you enjoyed this video, please subscribe below, and thank you for watching.